All right, well, good afternoon, everyone. Welcome to the Environmental Law Institute's webinar, Community Lawyering for Environmental Justice, Part 4, Working with Non-Legal Experts. My name is Madison Calhoun. I'm the Senior Manager of Educational Programs here at ELI. I'm going to just give you a few quick logistical notes before turning things over to our fantastic group of speakers. First, I want to thank everyone in the audience for taking the time to join us today. I also want to thank our speakers for putting in the time and energy to prepare such a great program for everyone. We at ELI are so grateful for your participation. As you probably know, this is the fourth part of ELI's Community Lawyering for Environmental Justice series. You can find the other 3 parts on ELI's website. We are offering CLE in a couple of states for this webinar. ELI is an accredited CLE provider in Vermont and Pennsylvania, so the program is automatically approved for 1.5 hours of standard CLE credit in those 2 states. Additionally, the program is pending approval for 1.5 hours of standard CLE credit in California. Please note, though, that California's CLE website reports that it takes about 4 to 6 weeks to review CLE applications, so we likely will not hear back from them until early 2023, which may be after your reporting deadline if you are reporting CLE in January in California. Please check your state CLE guidelines to see if your state offers reciprocity with the states in which we are pre-approved. In order to receive CLE for this event, you will need to fill out a Google form with a code we are providing during the webinar. I will put the form in the chat in a moment, and we will provide the code verbally and in the chat later in the webinar. We will send our uniform certificate of attendance to everyone who correctly submits the code and who we can track attended the webinar via Zoom. If you're seeking CLE in a state in which we did not apply for accreditation and also which does not offer reciprocity with Vermont or Pennsylvania, you'll need to apply for CLE individually. Please contact me at calhoun@eli.org with any questions. That's calhoun@eli.org, and I can help you out. I'll be helping to monitor the webinar in the background. If you have any issues or logistical questions, please reach out to me via direct message or over email. I'm here to make the event as great as it can be for all of you. And with that, I will go ahead and turn things over to our wonderful moderator, Christine Perry. Christine is a staff attorney committed to advancing human rights in the environmental context, with a particular focus on gender and disability. She works primarily on international issues with a focus on Latin America. She has experience in judicial training on deforestation issues in Colombia, environmental crimes in Peru, migration with dignity, as well as enforcement issues more broadly. Christine also works with ELI's Pro Bono Clearinghouse, and she holds a JD from the Ohio State University Moritz College of Law and a BA in Spanish and Creative Writing from Denison University. She's admitted to practice law in Ohio and is a member of the Global Network for Human Rights and the Environment. Christine, I will hand things over to you. Thank you so much, everyone.
Thank you, Madison. And again, welcome to our 4th CLE in this series of community lawyering for environmental justice. I'm thrilled to be here with our panelists today. Welcome to the people attending live and to the people that will be watching this later. A brief introduction to the Clearinghouse. The Environmental Law Institute's Pro Bono Clearinghouse is a place that connects communities, individuals seeking pro bono representation in environmental justice and environmental matters with Clearinghouse member attorneys willing and able to help them in these matters. If you are not a member of the Clearinghouse, please visit our website, which I'll put in the chat in just a little bit, that it is open to ELI and non-ELI members. And again, thank you for being here. Thank you for engaging with the Clearinghouse. We're going to kick this off. What we're going to do is I'm going to introduce each of the 3 phenomenal speakers. And after I introduce each one, they'll have roughly 10 minutes or so to give an introduction to their work and how they engage in this space with non-legal experts on environmental cases, including environmental justice, environmental cases, and pro bono cases. So let's start with Scott Gordon. Scott is a retired professional of the U.S. Environmental Protection Agency's Southeast Regional Office, Region 4 in Atlanta. EPA Region 4 covers the states of Alabama, Florida, Georgia, Kentucky, Mississippi, North Carolina, South Carolina, and Tennessee. Scott earned a Bachelor's of Science in Chemical Engineering from the University of Louisville. He is with the EPA for 36 years and has worked in compliance and enforcement areas in most of the federal environmental statutes and served as enforcement coordinator and chief of staff for the regional administrator in Region 4. Scott has received numerous awards for enforcement work, including national commendations for work on the City of Atlanta sewer problems, Jacksonville showcased community efforts and regulatory approaches to combined animal feeding operations. He also received EPA's 1999 Best Practices Award for outstanding innovations in enforcement and compliance assurance for publicly owned treatment works management operations and maintenance self-audit initiative. Scott retired from the US EPA in January 2020. Post-retirement, he was nominated and received the Ira Layton Jr. Lifetime Leadership Award, the agency's highest career achievement honor, 4 months later. He has since served as an Environmental Protection Network technical advisor for the last 2 years. Scott, thank you so much for joining us today.
Thanks, Christine. Thanks for that introduction. Hello, everybody. I really am honored that I get to go first as the technical person in this equation and give you my perspectives on being an expert and when you might need an expert yourself. Off the bat, there are 4 things that come to mind when you might need an expert. 1, there's a very technical point that is key to solve your case. 2, your legal team actually wants or needs technical validation for what they've already heard. Number 3, the success or failure of the stakes of this particular issue are so great that you have to know. But more common, the other side has 1, 2, 3, or a bag full of experts already, and you don't want to miss out on that opportunity yourself. So let's assume you've already made the decision that you want an expert. And as a former federal employee who worked a lot of cases, and we had a lot of experts themselves, we actually had to screen those individuals quite carefully. And I would suggest that it's really a two-way street. You, as the legal side, should be screening that person, and that expert should be screening you too. In my opinion, a good expert is trying to really narrow the range of that expert testimony that you might need to be successful for the case. And you, on the legal side, really want to make sure that that individual is going to be a good witness, because ultimately they might have to actually testify in open court. And one of the key things I've always asked our experts over the years is, how would he or she or they actually respond in open court to a question in their area of expertise that they didn't know the answer to? Their response is very important, because if they start rambling off in any direction other than saying, I actually don't know, which is the safest and most responsible answer, then you need to be very leery of that individual. Because I always remind people, in being an expert witness, you are also a witness first. You really need to abide by all of those good techniques for testifying. And honestly, this is where the conflict in having an expert in the first place is, because they're so full of stuff they want to actually say to everyone that it really, being a good witness often is in conflict with that, because you really need them to be clear, concise, and thoughtful in those responses, and make it understandable to everyone, whether that's jury, judge, or the prosecution, or the defense. So again, it runs at odds with what they really want, because they really want to blurt things out. And I'll give you a case in point that unfortunately I personally painfully witnessed this in my years. It was an administrative forum. Our expert got on the stand, and they were cross-examined to determine their expertise. And by the time the defense was done with them, this individual had validated that he was an expert in so many areas of environmental protection that it was dizzying. And of course, it fell right into the defense's hands, because they started asking this expert in very technical questions that weren't in his area of expertise. And did he say, I don't know? Nope. He had already dug that hole and he had jumped in it. He started testifying to all kinds of things that contradicted, of course, previous testimony and future testimony, because the agency had its own plan on how we were going to shape that course. And this individual was not going to be the expert in groundwater monitoring. We was not going to be the expert in financial assurance or any number of other things that he jumped into. So my advice to you all is, if you're ever in that situation and it looks like your expert is suddenly the biggest genius in the eyes of the opposing counsel, you need to stop them any way you can before they start testifying on brain surgery and other things that really won't be that important to you later in the case. So that was really my experience in my first 36 years working with the agency, a very structured one. But in my more recent years with the Environmental Protection Network, I would actually add a fifth example to that expertise area. When it is, and it is, when it's the case, your case of first impression. It's an area that on the legal side, you really don't have as firm a footing as you think you might need to have. I worked in several pro bono efforts so far since retirement. And I've met a number of very skilled attorneys and advocacy groups that frankly have little to no experience in the environmental area that is the problem of the community, of the local area, or of individuals. In those cases, a skilled technical practitioner is really important in helping them screen those cases in the first place, to truly bracket it in the right statute and the right regulatory structure. And to really understand the long-term issues. I'll give you an example. I was working with a group of attorneys who were very, very talented, had taken on the responsibility of working with a disadvantaged community on some truly, truly epically bad sewer problems in this disadvantaged low-income community. We went through Sewer 101 and we talked about sanitary sewer overflows and pump houses and pump stations and collection systems and all kinds of fun things like that. And they were feeling pretty good about their overall case until they got the first block of expert reports in from the other side. And they called me quite dejected and said, it's been a good run, but now that we've read this, we really think that, we really don't have a significant case to go on. I said, well, let's actually talk through that. And I said, if you don't mind, share those expert reports with me, because with what you described so far, I'm interested in what another professional would say about those situations. They sent them to me, and I called them quite quickly and said, your case is not damaged at all by this. This is an amazing amount of words on paper. Most of them are environmental words, and they mean absolutely nothing to the core element that you have here. The discharge of the unpermitted discharges of sewer to waters of the United States. They've said a lot of things, but as you all know, it's the unsaid that is just as damning as the said. They didn't talk about any of the issues that were truly impacting the community. They talked round and round and how much it cost and how much it might cost to fix it, all of those things. And again, to someone it's the case of first impression, it's quite overwhelming. They've got a 30-page report that says exactly what they don't need to see, and that the utility itself is absolutely should be held in high regard with all the work they've done so far to help the community. In fact, it's not true. And by the way, that case is progressing along just fine now, that they've been able to whisper, we don't actually believe that, or thank you, that's interesting, but it really didn't help your matter. So I will stop there. I'm always worried about my 10 minutes, but there are a lot of situations where an expert is needed. There are a lot of situations where an expert might be detrimental to your case. So I wish you the very best in your upcoming cases.
Thank you very much for that, Scott. Now, I'm pleased to welcome Lisa Jordan. Professor Lisa Jordan is the director of the Tulane Environmental Law Clinic. A native from New Orleans, Professor Jordan began working at the clinic as a supervising attorney in 1996. Shortly thereafter, she took on the lead attorney role in the clinic's representation of a grassroots group called the St. James Citizens for Jobs and the Environment, and its regional and national partners in their successful fight against the location of the Shintech polyvinyl chloride complex in Coven, Louisiana. The clinic's multifaceted work in this fight on behalf of a community already overburdened with industrial pollution earned it the runner-up title for the National Law Journal's Lawyer of the Year. Unfortunately, environmental justice, pollution, and public access issues continue to proliferate in Louisiana. So Professor Jordan and the students and supervising attorneys at the clinic remain engaged in the representation of individuals and groups who are impacted by pollution, with a focus on those without the resources to hire an attorney, including disproportionately impacted minority communities and individuals. Lisa, we're so glad to have you here today.
Thank you. Thanks, Christine. Hi, everybody. I thought I would focus my comments on the different types of cases that we've used experts on and the different types of expertise. I think Shay's going to do the tips angle, which she's probably got a lot more experience actually litigating with experts. I would say a good 60 to 70% of our work with experts is written testimony. So, presents some of the same issues that oral, a verbal or oral testimony would present, and in particular that you need clarity no matter what, but some different considerations. You don't have to worry about loose cannons or anything like that. So I thought, it'd be helpful for me to, and since we've been doing this for quite some time, to sort of talk about the different areas in which we've used experts. Most of our work, as my bio sort of reflects, is on behalf of environmental justice communities. And here that's mostly fighting petrochemical facilities, petrochemical build out, new facilities or expansions of existing facilities. And so that type of litigation, and that's against both federal agencies and state agencies. So part of the reason why we do so much different kind of work, water work, air work, land work, is because when a facility comes to Louisiana, it's usually these, petrochemical facilities need all those kinds of permits. They need a 402 permit under the Clean Water Act to discharge wastewater. They probably need a 404 permit under the Clean Water Act because they're want to construct in waters of the United States, typically wetlands. And then, of course, air permits are a big focus. So we end up having to find whatever is the best method of defeating something, and sometimes we have the capacity to do all those things. So we're looking to put expertise into our comments. So when we sue in Louisiana, and probably a lot of states, but when we sue in Louisiana on an air permit, we're suing the agency for issuing the permit under, basically it's an Administrative Procedure Act type challenge. So we're arguing that the agency violated the law in issuing this permit. And those kinds of cases, and that's true also if we sue the Corps of Engineers for issuing a 404 permit. APA cases are record review cases, right? Many of you know this. So you're limited in court to whatever you introduce to the agency during that process. And the theory being, and this is part of the challenge of litigating these cases, the theory being that the agency is the expert. And so the agency is the one that should be in the first instance, right, reviewing the various issues that come up and opining, it's applying its expertise, not the court. So that's the theory behind, why you've got to present to the agency before you can present to the court. So you're basically limited to whatever you gave the agency. That's why it's not going to be, verbal. It's going to be mostly in writing. So that's what we do. And again, the same with the Corps. Biggest focus is clarity, simplifying the testimony. It's the biggest issue, but it's also the biggest challenge. It's the rare expert, at least in my experience, that can really say things in a way that's simple enough. They think they're dumbing it down so much, and it's still not good enough. I should say dumb enough, but that's not the right that's not the right connotation. But basically, it really needs to be simple for a judge to be able to understand it and not want to just throw up their hands and go, this is complicated. I need to go with what the agency said. So that's our biggest issue, getting clear testimony. So basically, you know, we're working with the expert during sometimes a 30-day period. And it's not a lot of time to develop an entire expert affidavit in 30 days, but that's the typical comment period here. So I guess one of my few tips I'm going to give is one sort of cheat that we've developed, and it's worked pretty well for us. Because 30 days isn't enough time often to get a declaration or an affidavit in a simple format. You just, you know, the expert is, again, trying to make it simple. It's still not simple enough. And yet they've written the whole thing and it's detailed and we can't start from scratch. What we do is we'll put like a section in the very beginning called summary of opinions. And it's basically a bullet points of the key issues that the expert has raised in the report itself or the affidavit itself. And it's our, basically the lawyer's sort of summary of how we are viewing that testimony. And of course, the expert reads it and agrees to it, but it's our little piece where we can sort of put things in a way that we think it's understandable, and the expert has every ability to edit it or change it. But sometimes it's just not going to get there unless the lawyer can kind of be the one to craft the language. But then the opinions themselves, of course, are the experts. So some areas in which we've used experts, citizen suits, certainly we filed citizen suits, and Shay probably has that experience as well, but under the Resource Conservation and Recovery Act, the Clean Air Act, the Clean Water Act, we've used testimony to support claims of imminent and substantial endangerment under RCRA, and, you know, various experts on Clean Air Act and Clean Water Act suits. Our philosophy on Clean Air Act and Clean Water Act suits is typically to make it simple for us and prove the case through the reports of the permittee. And so mostly our experts in those cases are reactive, or they're focused on a particular issue like penalties, and there's various factors for penalties. So we have a specific expert that talks about economic benefit, right? That's one of the factors for a penalty, is how much did the company benefit from not using the pollution reduction technology. And there's some people that have very specific testimony on that, but that's one example. But we've used toxicologists to evaluate plans for remediation in RCRA suits and to develop opinions on that. We've used zoning experts. We had a state case that involved a drilling permit from our state agency, and the area was zoned for residential use. So there was a preemption issue, and we used a zoning expert to sort of explain why it matters, why it's bad, why it matters to have an industrial use in a residential area. Sewage, we've done some sewage suits, again, you know, Clean Water Act suits where sewage has come up in environmental justice communities' yards. We've had, you know, experts in sewage design to help try to figure out, you know, what the problem is and how to resolve it. And let's see, we had a pulp and paper mill permit. We had an expert on those discharges, water discharges being one of the big ones from that, but there's air issues as well. We've had groundwater experts review information. In more than one instance, we had a power plant that was going to be using a lot of groundwater and submitted a report saying it wasn't going to, you know, pose a problem for the aquifer. So we had an expert to review that and critique it. We use hydrologists quite a bit because of the 404 permitting by the Corps. We use hydrologists to demonstrate that the dredge and fill activity will pose a problem for the wetland area. Environmental engineers in Clean Air Act suits, we've used them in comments to show that a facility is actually a major source when it's trying to get in under a minor source permit. That's one example of, you know, a way that you can comment. And we've got air modelers that will review air modeling that supposedly demonstrates there won't be a violation of the National Ambient Air Quality Standard, to review it and say, actually, this shows that it will, or the modeling is faulty for X reason. And then, you know, we've done amicus briefs where the expert is the is the amici, or the experts are the amici. We've done gopher frog experts, thoracic surgeons on a EPA crystalline silica limit. So lots of, kind of trying to give the gamut of, various areas in which you can use an expert. And finally, one thing we did recently that we were really happy with, it was a little bit of a different kind of expertise. We're representing a community, an environmental justice community that's fighting a grain terminal. So grain elevator, docks, silos. And the big issue with the facility is it's going to be right on top of the community. I mean, like only like 100 feet from it's really shocking. And we were frustrated in the fact that it's not, this is a challenge. It's not there yet. How do we demonstrate what this thing's going to look like? We hired a company to look at the schematic of the silos and to basically superimpose it as it would look from the community. And it's been really impactful. Like, this is what it's going to look like. So we were happy with that, but I'll stop there, and I'm sure there'll be questions later on.
Thank you, Lisa. And yes, to everyone, please feel free to put your questions in the Q&A box once we go through all the presentations, and we will get to them towards the end of our program. And last but not least, I'd like to welcome Shay Sahai. Shay is a leading energy and environmental attorney and helps clients nationwide shape laws through legislative and regulatory advice. Prior to joining Foley Hoag, Shay served as in-house counsel to the largest renewable fuels producer in the world. He is acting general counsel of the largest renewable fuels trade association and directs legal and policy strategy on climate, environmental, and sustainability issues at the federal, state, and international levels. He also actively advises clients on community and stakeholder engagement related to Native American and environmental justice groups, among others. Welcome, Shay.
Thanks so much, Christine. I really appreciate it. So I think I'm going to take a little bit of a step back and provide just some tips on working with experts that I think I've developed over the years of practice, and then discuss some considerations with respect to working to experts on matters that might be pro bono, which is kind of what's in my work in the space is currently. So starting with the general tips for working with experts. I think the number one tip that I have is that you really need to build a trusting and working relationship with your expert. So this is not unlike any other relationship in your life. It could be colleagues, it could be family members, but it's really important for the lawyer and the expert to trust each other and to trust each other's feedback. So you need to do all the things that you would do to build a relationship in any case. You need to get to know them on a personal level. I suggest doing things kind of outside of the workplace, going out to lunch, going out to dinner, but having that, again, trusting relationships so you can have an open dialogue on issues, I think is really foundational to the relationship. Second, you have to defer to the expertise of the expert. This seems relatively obvious, but not all attorneys take this approach when dealing with experts. So when it comes to their core subject area, right, don't let them voice their opinions and kind of express themselves on the issues they care about and know the most. So flipping to the other side of that, then what is kind of the role of the lawyer in the relationship if you're kind of deferring to the expert's expertise in a specific subject area? So I view the attorney as a kind of mentor or conduit between, the factual and knowledge base of the expert, and then the kind of strictures or structure of the law and the legal profession, right? And sometimes those are different universes. So again, the expert knows what they know. Our expertise is how might that information fit into the body that you're trying to persuade. So that could be, a court, right? It could be a regulatory agency, as Lisa addressed. But our expertise, again, is understanding where the facts fit in the legal structure. And so I think the experts, can feel very confident in their own views of the science, their knowledge of the science, but where they get nervous, right, is, well, how is a court or how is a regulator going to view what I have to say? And when should I be deferential to a court or regulator? And when should I push back against what they're saying? And I think that's where, mentoring from a lawyer comes in handy. And that's really what I think our job is when we're dealing with experts. So another way to think about that is to recognize, our own expertise, right? Again, our expertise is in translating, understanding the facts and then translating those into the specific scenario at hand with respect to the law. So how do we help do that? My advice on this is don't be afraid to ask questions and perhaps even ask the dumbest questions possible, right? So it's really important that that you fully understand all the assumptions that the expert is making, and don't be embarrassed about not understanding things, right? We're lawyers. It's not our jobs for the most part to go out and profess our understanding of this material. That's the expert's job. But asking dumb questions can do a couple things. One, it might actually reveal a methodological assumption that the expert is making and hasn't fully thought through, right? Maybe your question isn't so dumb. Maybe it's just a basic thing that he or she usually assumes, and that's worth revisiting. The other thing it can do is it can prepare the expert for the types of questions they might get, right? From an opposing counsel, from some sort of adjudicator, from some sort of regulatory body. They might think that these entities are operating at a much higher level in terms of depth of understanding, and you asking dumb questions will prepare them to be able to respond to these other folks in a way that they might be able to understand. And then my final tip, which kind of follows up on some stuff that Scott said, is that you have to be okay with the expert coming to conclusions that are not necessarily helpful to you. So if you pressure the expert to go one way or the other against his grain, that can end up backfiring you if they are in a situation where they're unable to back up their conclusions, right? In addition, I think the experts are the most credible when they're most confident about what they're saying, right? So you have to be kind of okay with them disagreeing with maybe making some statements that maybe don't further your points if they're saying other things in their report that are generally helpful. Finally, kind of being deferential or being okay with things that are not favorable to your case could lead to some favorable outcomes. One, it could allow you to reassess the weakest points in your case, right? So maybe you've been heading down a certain litigation or regulatory strategy. Hearing from your own expert that seems not the best case might lead you to change focus, might lead you to a different advocacy path. It might lead you to follow a different kind of factual basis for your advocacy, or it might even make you reconsider what you're advocating for, what your strategy is, and how else you can help the client. I think all those things are helpful. The other thing that it can do is call attention to when you might want to bring in additional help. So let's say you have an expert, they are kind of asserting things that aren't helpful to your case. You think that there's more there. Well, that's a situation, right, which is then a red flag or a yellow flag, and you can bring in other experts. And those experts might, again, agree with the expert at hand, and that might, again, cause you to go rethink your strategy, or they might disagree, in which case you could use that other expert in a couple ways. You could use them to go back and ask more educated questions of your initial expert, or you might decide that perhaps the second expert opinion is more reliable in this case and might be more helpful to your arguments. So those are kind of some basic tips I've developed over the years in dealing with a variety of experts. So let's turn to dealing with pro bono experts in particular. So one piece of advice I have in dealing with community organizations is that it's very helpful to have an expert that either has a relationship to a specific community or that has the demeanor where they're able to build those relationships. So often in cases where you're organizing communities, it's important for the expert to be able to elicit factual input or other types of input from community members. If they're from that community or they have the demeanor where they're able to build that, that's a whole lot easier, which then makes it easier for the expert to build out the case. Second, it's really important to keep in mind that in a lot of these pro bono matters or community-oriented matters, the experts are working for free, right? And that creates a very different dynamic between the attorney and a typical expert, and then the attorney and a pro bono expert. If you're working with a paid expert, you have a lot more flexibility in setting deadlines, kind of setting expectations for work product. When you deal with pro bono experts, you know, they can be obviously equally skilled or more skilled, but you have to take what you get a little bit more, right? So if people are volunteering on their free time to help you build your case or help this organization, you can't necessarily make the same demands you would of a paid expert. So you have to be a little bit more flexible, maybe a little bit more willing to shape your case to what the expert is willing to say, rather than kind of telling the expert, well, these are the specific areas you need to address in your report. In the description of this panel, you had also posed a question of when it is appropriate to first engage an expert. And my advice on basically all the matters that we've been discussing involving environmental issues today is really as early as possible. In most environmental cases, you end up getting extremely fact-specific, and it's almost impossible to really dig into these details, especially when something becomes a controversy, whether that's regulatory or adjudicatory, without really the help of an expert helping you dig in and understand the issues and helping you make the best arguments possible. So my advice, again, is as early as possible, go ahead and reach out to those experts and get them engaged. So I think that brings me about to my 10 minutes. So let me hold off on additional points and we can come back to other issues in the Q&A.
Thank you so much. And thank you also to Scott and Lisa for your interventions as well. So now I'm going to throw out some questions. These are for all of you. And yes, we'll just see how the conversation goes. And we also would like to remind the audience to put your questions in the chat. We are saving room for that. And I think, you all touched upon that it's better to engage an expert earlier. They will help you build your case, help you identify weaknesses, really the best route for your strategy. But this, and I think it was you that said it, Shay, don't be afraid to ask the dumb questions. So that's what I'm going to do. How do you identify an expert? How do you find them for, say a pro bono matter, say for a non-pro bono matter?
So I'll hop in here and then other folks, please feel free to jump in. So I think there's maybe three ways that I think I would go about doing this. I just thought of a fourth one too. So the first one, I think, is relying on your existing expert network for referrals. That's probably one of the strongest things you can do. So you've got, like, scientists, no other scientists, right? Especially in the environmental community. So chances are one of the experts that you've used on your prior case knows someone who works in this area. And that's often an excellent way to develop, to learn about kind of who is, who's helpful in the profession. Second, especially in these pro bono matters, you might walk into the matter with experts already engaged with the organization, right? And that goes for paid matters also. So your client, whether it's pro bono or a typical private client, may have experts that they've been using for a long time and want to continue to use them. So obviously you can tap that network, and sometimes clients might be pretty opinionated about using people they've already been using. Third is random Googling. So that's actually pretty effective sometimes. So I've done plenty of cold calling, right? Where you either Google or, use your law firm resources or whatever other resources you have to essentially just find out who appears to know stuff in this area and just start making cold calls and develop a network that way. I've done plenty of that. And then the fourth one is there actually are firms And again, this is probably less helpful, but in a pro bono or community-oriented case. But there are firms that specialize in going and finding experts for you, which I just recalled. And so you can hire them to go kind of comb the network of experts that are out there and come up with suggestions. But those are the kind of four ways I can think of right off the bat.
Thank you. And Lisa, I'm wondering, is this different in an academic clinic? Are you able to tap into your university's resources, different departments, or is it similar to what Shay was describing?
It's similar to what Shay was describing. Unfortunately, we're a little controversial even within our university. So we don't get as much help as we might like. We pretty much do the same thing Shay had the methods he suggested. We also have a staff scientist who works for our clinic and is able to kind of access some networks that we, that others might not be able to. Having said that, as long as we've been doing this, we still have trouble finding experts. For certain things, there's only a few people, like a couple people that do this, either pro bono or low bono. And it's sometimes hard if those people aren't available. Often there isn't anyone else. So it is a challenge.
And I do want to come back to your staff scientist, but I want to ask Scott, how is it on the other side for you, and especially with your work with the Environmental Protection Network?
So, Christine and Shay, one thing first, there is no such thing as a dumb question. Those are the most valuable, as you all know, and Shay illustrated it. They are the most valuable questions of all. And this question is right down that alley. It's easier to say you need an expert than to find one. And especially in environmental situations, in a pro bono situation, it is very hard. I can give all kinds of advice from Atlanta to individuals around the country. But if they need someone to go out and look at a MS4 stormwater issue that is causing problems during a rainfall event, you need someone very place-based to that location. You're not going to have someone fly around, just hang out in, Montana, waiting for it to rain. So it is very tough. And I've had to rely on my own professional networks and try to find people in that geographic area. But it's a mighty struggle. It's a lot easier said than done.
Thank you. And I want to come back to what Lisa said about your staff scientist. So how does the scientist help? Are they an expert in a certain field, or do they help translate the science to more legalese for the cases?
Mostly the former. So really, how she has her own expertise, our staff scientist, but she's taught herself since she's been working here a lot of areas, that she didn't have familiarity with before. So, air regulations and what information is out there. She does a lot of our work sort of figuring out public databases. So when we can't find an expert, as I mentioned, sometimes that happens to us, then we try to gather what we can from public databases. EPA's got several databases about that you can learn about air pollution and environmental justice issues, EJ Screen being the main one. And she basically is able to sort of cull these databases and figure out what's out there and then take it and tell us how we can use it. So that's mostly what she does. Again, there's a few areas that she's an expert in, but we only use her sort of in-house and to help us write comments, not to testify, but she's been and to serve as a liaison in some instances with experts that we're having trouble communicating with, and also students, of course, are working on our cases, so she helps give the extra time to explain things that maybe we don't have with the hired expert.
Thank you. And I'm seeing two questions in the chat that relate to this conversation. So one of them would be that it's pretty common, it's very encouraged in the legal community for lawyers to take on pro bono cases, that a lot of state bars are actively requiring this, which is wonderful. But looking at that, it's not the same with experts. And so how do you encourage experts to take on these cases? And is there a difference between environmental consultants versus experts? And how do you make sure that that person you're engaging rises to the level of expert, that there is a clear definition legally of what an expert is, but how do you make sure you are working with a true expert?
Well, I can opine on the first part of that, I think, which is, how do you find pro bono or low bono environmental experts? I mean, if you're a firm lawyer, the answer is kind of relatively straightforward, which is go to the experts that you would otherwise pay and see if they want to help you out on this matter. So you're much more likely. First of all, everyone wants to do pro bono, right? And so, it's like everyone's gut. I think most people's hearts are going to want to be engaged in these cases. So you want to help them build a business case, right, for how they can spend their time on this, right, and then justify to their consulting firm or on their own bottom line if they have their own shop, how is it business? How does it make business sense for me to be spending time on this? And I think that would be by kind of dressing it up, right, as a marketing matter. Well, such and such law firm always hires us for this thing. Now they've asked us for help on a pro bono case. I think it's to help build the relationship, right? So I think that's like, if you're sitting in my shoes, the easiest way to get someone engaged or interested in the case.
Well, from the Environmental Protection Network, I think they've really filled an important gap trying to take the agency's historical knowledge base from retirees and moving that into an acceptable field of practice. I have, seen my colleagues around the country who are some of the best experts in the world in their particular areas really jump on to that desire to continue the service functionality that we all had when we were paid professionals. So I think it's really good. I will tell you, obviously there was a need there because I turned down 1 in 3 or 2 in 3 these days of offers to support major efforts, because once you get involved, it becomes a heavier lift. And I've tried to transition some of those individual cases into experts that I was comfortable with in that part of the area of the world. And again, it goes to lower bono than true pro bono. But that is a, again, I think in my world, in my current responsibility, trying to find that extra transition to somewhere who's going to need lots of case support to move that on. And I serve more of a screening mechanism, which I'm really comfortable with, and it doesn't interrupt my golf game.
And I'm not sure if anyone would like to touch on how you're making sure that what's the difference between a consultant versus an expert, and making sure that that consultant rises to the level of expert that you need in this case, or the legal definition of expert.
Well, over my experience, I've met a whole lot more people representing themselves as experts than experts. I hold that true expert, and I put it in quotations, for very few individuals. I think there are some very strong practitioners of the regulatory responsibility and their understanding that can be very beneficial, but it is tough. People usually need to be published, well known. In my own efforts, I've had to cross-reference with federal and state organizations, a lot of people I know in the corporate world, to try to validate, is Johnny as good as he says he is, or not? And a lot of those questions lead to the not side of that, unfortunately.
Yeah, I know that we've used, consulting experts being like somebody that we do not intend to use to testify in a case, to just help us to understand, whether we have a case sometimes, and and there's different disclosure requirements for those than an expert who you intend to use for testimony. I mean, I don't know the official definition of an expert, but I think assisting the court in understanding the issues is probably going to be, a key thing. If I'm using an expert to testify, I pretty much want to know that they've qualified before I would be. I mean, there's always a first time, right, for everybody, but I would be hesitant to use someone who's never qualified in any court or administrative proceeding as an expert in that area. And conversely, I would want to know whether that person has ever failed to qualify as an expert, and would want to know more about that if that happened. Those are just some initial sort of screening things, but sometimes you're going to kind of take what you can get and just be sure that the person interview them and make sure they have a background that fits, and of course work in the area.
Yeah, I might just add, so I think we've been focusing on the substantive knowledge that someone needs to perhaps be an expert. But then, the other piece of it is obviously is not everyone has the demeanor to testify, right, in front of a court or an administrative agency. And that's a huge difference, I think, between, a consultant or a consulting expert and then, like a testifying expert. That even goes, that goes in the formal sense where you're up in front of an Article 3 court. But even, folks who you put up and bring to agency negotiations, not everyone is even up for like an EPA meeting, right? And so it's a different skill set. You just have to, use your judgment to see if you think people have the personality to go into those different modalities.
And I would like to come back to that testimony aspect, but one further thing about finding experts, one of our audience members asked, I think this would mostly go to Lisa, maybe Shay, in your pro bono work, have you ever used outside funding to help pay for an expert that's not going to be pro or low bono? Do you have any tips or experience that you can talk about in this area?
We have a lot, actually, and in general, we much prefer to pay someone, even when they're willing to do it pro bono. Quite frankly, it's sort of some of the issues that Shay brought up. Like if we're paying someone, we can set some deadlines, and also, quite frankly, I've had it sort of used against someone that you're doing this for free, so like you're a believer, right? Like you've got an agenda kind of thing, whereas experts are supposed to be objective. So we definitely do try to pay them, and we do have funding and have gotten funding to pay them. One challenge is to get the funding to be broad enough that it can cover that or something else, because when we've sort of specified in a budget that we want X amount for an expert, well, the problem is funding only lasts a certain period of time. And if you designated it as, I want this amount for expertise, and you haven't been able to use an expert in that time, then you have to give the money back. So we try to be broader in our budget, and just so that we can cover it. But there is funding out there. There's actually one fund that specifically funds experts, but you have to get it in, and they have it 4 times a year. So yes, we've had some success in that.
Yeah, and I just said, like, look, there are rates and there are rates, right? And so, the same consulting firm or testifying expert might be very expensive, right, if you're going to hire them to represent a Fortune 500 company. But again, they might cut a much more affordable rate if they, believe in the cause or want to assist the community organization. So it's always worth having the conversation, even with someone who seems too expensive, because who knows whether they might just kind of cut a low bono deal there.
Thank you. And coming back to testimony, I'd like to hear from you, from Shay, Lisa, also Scott, in your personal experience. How do you best prepare an expert for testimony? What would you say you should do, and really, what shouldn't you do when you've made it that far, you're going to court, you're going to be in front of an agency, you might even be just at an EPA meeting? How do you make sure that that expert comes across well?
Scott, give us some tips on kind of what
you want to go? Okay. Well,
yeah, go for it, man.
So I've appeared as an expert. I've appeared as a fact witness. But Shay, goes to a lot of things you said earlier. Understanding the relationship and understanding the full focus of the case is really important, both on the technical and legal side. You don't need to be surprised when the expert goes off at a 45-degree angle on a subject that you haven't discussed. It goes back to that practice makes perfect. Our best experiences have always been going through a full-blown mock-up of that with prosecution and defense, and ugly questions in a conference room where nobody gets to see it. I think I've testified 9 times in different administrative, civil, and criminal matters. And the ones that feel the most uncomfortable are the ones that were thrown together at the last second, sometimes not on anyone's particular to blame, but those are very uncomfortable and very unwieldy as a witness. But again, I would also go back to what I said earlier is, making sure that the person is a good witness first is the key to making successful testimony. And not everyone is as we talked about it just a minute ago, not everyone is a good witness in those situations. It's hard enough to getting out just the facts in a clear and thoughtful way, but to be cross-examined and harangued in that process takes a little bit of mettle and a little bit of fortitude in remaining calm.
I would also add, we've definitely had some experts that have testified a lot. And when they're doing pro bono work or even low bono work, often they want to skip out on preparation. Oh, I don't need to do this, right? I've testified about this literally dozens of times, and and actually fight us on getting them in a room and running through the mock that Scott just discussed. Insist on it, no matter how many times they've testified. Insist on that. Going through the questions, whether even in a deposition, right? But even for deposition testimony, I would definitely insist on that. And the other thing I'd add is make sure they know your theme, the theme of your case, which is often not, and by that I don't mean like, here's why we win under the law and the facts, but sort of the overarching why we should win, why the court, we win, and here's why that's a good thing, right? Your theme is that here's why that's a good thing. And I think it's important that the experts sort of understand the broader background of the case. It comes up in strange ways, but I think it's an important thing.
Yeah, I think I just add that this is where your relationship building with the expert really comes in handy, because I think understanding the psychology of where the expert is likely to go in different situations is pretty important, right? So, some people might tend to get silent, when questioned hard. Some people might, kind of be people pleasers and almost try to please the person that's asking them the question. Other people might be more combative, right? And your job is to, depending on the forum, you'll have a different ability to do this, right? But it's to kind of coach them through the situation. I mean, I don't mean coach in a bad way, in a non-permissible way. You get what I mean. But like to help them get through the situation, right? And so again, the more time you spent, with this expert, building a relationship, understanding their psychology, the more you'll be able to predict and then help them get through difficult situations, the types of things we've been talking about.
And so coming off of this, 2 follow-up questions. What happens, and I'm sure this does happen, when the expert, it doesn't go as you practiced, that they go off on a tangent, they say what they said they weren't going to say, or say that the expert's testimony contradicts another witness's testimony, a factual witness testimony. How do you reconcile that? And how do you get the expert back on track if it's gone off the rails during a cross?
Well, that's where the attorney really makes his or her money. That redirect is key. And again, that goes back to really understanding the overall theme of the case. Hopefully a couple redirect questions will allow the expert to connect with the ground that he or she is supposed to be walking on to move the testimony forward. And again, it really takes a lot of skill with the attorneys to responsibly redirect that into the right arena. And I've seen good ones, and I've seen some really indifferent ones.
Yeah, we only have one tool, right? Which is asking questions. That's all we can do. That's obviously true in court, but even in an agency meeting, if your expert just said something weird, you can't contradict them yourself, right? You still only have one tool, which is like, oh, you just said this. did you mean this in this context? Or you can just ask them in agency meetings, actually, you have even more flexibility. You can just ask them about the contradiction, right? So you can say, oh, well, Dr. blah, 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 you said this, but this other report says this. Can you reconcile the two for, this agency, right? I mean, you could be that in agency meetings. I think you can be that straightforward, right? At court, it's a little bit trickier, but.
Yeah, because usually in the expert's mind, they're not in conflict. They know why that connects. It just, the words that came out of his or her, their mouth didn't make it look like they connected or they were at odds with each other.
All right, and then this question is another one from an audience member, that considering that there's some flexibility in who can qualify as an expert, that we typically lean toward professional academic experience, do we ever consider people from the community with lived experience as an expert?
We've definitely I think the answer for mostly is we have not done that, but we have offered the testimony of community members, not as an expert, but to talk about their lived experience. And when the expertise is the most effective is when it basically proves what the citizen, what the resident in their experience, I've noticed, this or that, and then the expertise can back that up. So we haven't tried to qualify a community member as an expert, but that doesn't mean we haven't found ways to introduce their testimony.
Yeah, and we've certainly, in my past agency experience, we have certainly put them on as fact witnesses. They're the ones who are living, breathing, feeling it every day, and those are some of the more compelling testimony you're going to get in the court's eyes. But not going as far as to try to call them an expert there, but a true on-the-ground fact witness is really key.
Yeah, I agree with that. We kind of we're kind of stuck with how our legal system, right, defines experts versus fact witnesses. So I think the expertise of those people exists, but it just fits within kind of the legal framework we have in the fact witness box rather than the traditional expert box. And it's going to take a lot of case law in a long time if we get to change around that structure. So that probably won't happen soon.
Thank you. And then, sorry,
I just want to add one thing that was one sort of area that seems to be up and coming, and at least in federal court, is standing challenges to the standing, especially in citizen suits, is getting harder and harder. And one of the standards is whether the person is, has reasonable concerns about something that's affecting them, right? And so they say, I'm concerned this facility's discharge is doing this. It's getting to the point where you may even need an expert in some instances to support the reasonability of the residents' concern. So that's one area in which it kind of fits pretty closely together.
Thank you. And looking back, we're going to take some more audience questions. So if you have them, please submit them. Like Scott said, there is no dumb questions. And I think, was it Miss Frizzle that highly encouraged questions as well? I might be dating myself with Miss Frizzle reference. So the next question is, if you have multiple experts that you're considering, say that they're all accessible in a cost sense to you, what are the things you look for? What makes them really stand out to you that you'd go with one expert over another? I know that we touched on experience, that they've done it before is really important. That they have the ability to do it and do it well, but are there other things that you should look for? I mean, I know we said personality also.
For me, the biggest factor, frankly, is their ability to simplify, sort of building on what I said before, their ability to draft something that's simple. That's because it's so hard to come in and do that if they're not able to kind of do it themselves. And it's going to have such limited utility if it isn't understandable. So that's kind of obviously, you need to be willing to work with you, but that's kind of my number one thing that I'm looking for.
Yeah, I think it depends on the situation because, in front of certain bodies, the gravitas associated with someone's resume might have a lot of value, right? You know, versus Lisa, I think what you're saying as far as, you know, talking to juries is an essential component, right? But if the body you're talking to is already experts, then that's, you know, probably a little less important, and, you know, maybe the resume matters more. But even in that case, you want someone, you know, who can effectively communicate. So I'd say, you know, it varies a little bit depending on the specific audience you're from.
And then this question seems to be very popular about, you know, who can be an expert. And I think, Shay, that this might be up your alley with your work with Indigenous groups. But can proven Indigenous knowledge qualify as expert knowledge? And can those that possess this knowledge be accepted when that they might not have a certain, you know, educational background or degree that goes along with that knowledge?
So in front of administrative bodies, the answer is absolutely yes, right? So the Biden administration just kind of reinforced its commitment to an executive order recognizing Indigenous tribal knowledge. So certainly if you're meeting with the executive branch, this is like a recognized type of expert knowledge. And I think we'll receive you know, deference and respect from the agencies you're meeting with. In front of the courts, though, I mean, going back to my earlier point, I think, you know, depending on the situation, this might fit more into the fact witness box than the traditional expert box, right? Because if you're going to get past the Daubert motion, how are you going to do that, right, with Indigenous knowledge? It's hard based on kind of the types of things that deem you an expert in our traditional legal system. So that's, you know, certainly an area for potential reform under current rules. You know, my gut would be that if you have kind of Indigenous knowledge kind of mainly in traditional sense without the academic qualifications that traditionally are used to characterize experts, it's going to be hard for a court to recognize you. But again, in front of administrative agencies, I think the answer is they are ordered by the President of the United States to be respectful of that body of knowledge.
Thank you. And then this question, it's really more of, I guess, policy question, but looking at how can we elevate the knowledge of courts, that this information that usually in environmental cases is so technical. And I think, was it Scott or was it Lisa who said you want, so the judge just doesn't throw up their hands and goes, oh, it's too complex. So is there a way to assist courts in this? I know that the experts should be easy to understand, but are there other ways that we can aid courts in really raising their level of understanding so that these cases are more accessible to the judiciary?
Well, certainly knowing the court that you're going to go into is key. Looking at those past decisions, there were certainly circuits that we were more leery about dancing into than other circuits. And, you know, to the degree you have the ability to forum shop, you should take that into consideration.
That is a good point, actually. I mean, my answer on my experience, I can't think of a way to say yes to that question in front of courts. We've just had to sort of slog it out and sue enough times that the bench as a whole ends up educated, although where all of our judges are elected here. There was actually a proposal to have a business court here in Louisiana that would only hear environmental cases, which we were very against, even though it certainly probably would have accomplished what the question raised. But the problem is there's a lot of money from industry lobbyist groups to put judges on the bench. And so we were very concerned about it being just a stacked bench if it happened that way. But that would have been one way to address that issue.
I know that at ELI that we do a lot of judicial training that where I'm currently finishing up a project on training judges on deforestation issues. to help, increase the capacity of judges in Columbia to take on these cases and to really understand them. But it is a major thing, making sure that judges have the tools that they can take on these cases and feel comfortable with them, because environmental cases can be, they can seem scary at first because they are very technical, but they do involve a lot of science sometimes.
Yeah, it's like the choices are basically to work within the system you've got or change the system, right? And so you can try to. I mean, we have a weird system of kind of adjudicating controversies, right? Where two people hire lawyers and go against a third party who might know nothing about that particular issue and yet decides whether one of these two parties is right. It doesn't seem particularly efficient in a lot of cases, but that's what we've got. And so you can either elevate the knowledge base of that judge, which is, Christine, I think what you're talking about, or you can try to come up with a different system, which is, Lisa, you referred to one attempt at that. You could try to refer certain factual issues to experts, like a judge might have the discretion to do that depending on the jurisdiction. So there's some different ways to deal with it, depending on well, I guess that's all within the current system, aside from what Lisa said. And then you could just, if we really want to get creative, develop, a new way to adjudicate this type of matter when the traditional system is not particularly efficient.
And it looks like we have one more question from the audience. So I would like to remind the audience, we probably have time for one or two more questions if you have any that you're sitting on. But this comes back to what Lisa said about the 30 days for comment making. So when you're working with experts, and even in litigation, the deadlines can be really tight. How do you make sure, especially if it's a pro bono or a low bono expert, that you're meeting these deadlines and you're working and you're getting the best work product? Scott, I'm sure you can talk about your experience as the expert and those tight deadlines, but also Lisa and Shay, how you encourage your expert to meet those deadlines.
Well, I think Lisa had the best solution, which is pay the expert. Certainly gives you more control to set deadlines. But otherwise it's just got to be a collaborative approach. I mean, hopefully you've done a good job of making the expert feel invested in the case, feeling like it's their matter. All the typical things you would do in management, I think, apply here. But again, if you are paying them, then that's helpful in being able to set deadlines, keep things on track. So.
Well, the other thing is most permit applications or most public notices of a 30-day comment period are preceded by months, if not years, of the application sitting with the agency. Now, there's a danger in appointing an expert too early or assigning an expert too early, because then the application could change as a result of agency comment. But that is one thing we've done to a limited degree is, okay, the application's in, the expert can start looking at it now, and we've wasted a little time doing that. So it's a balance, right? Like, we've had to look at it now. 30 days is not going to be enough for this one. And of course, don't forget about asking for an extension. Always try that. But put them on early, and then it changed. And so we had to go back to the expert again. But again, that's another option if there really is a concern that 30 days is not going to be enough time.
And this is a situation where, remain vigilant in your communication the whole time. Express to the expert the criticality of the matter. There's important, and then there's really important, and then there's a court-ordered deadline. Everything starts out as important. Let's just be serious. But as you step that up, an experienced expert understands the nuances of that ladder as we go up of importance.
And we have an audience member talking about engagement letters. When you first engage with the experts, that it's important to set those, standards and what you expect out of the relationship, as it is with anyone you work with your clients. And I would like to take a little time to ask you, I don't want to ask you your best experience because you probably have many to pick from, and I don't want you to rank your favorite experts, but I'd like you to share a good experience working with an expert and really the takeaways from that. And if we could do that in a pro bono setting, that would be really nice.
Well, I will. I was regaling my wife with this story earlier today about my favorite expert witness of all time. It was a very, very controversial RCRA environmental case where the court had been very adversarial to anything that looked like bugs and bunnies. And the expert that we had available to us was world-renowned, but he had one significant drawback. He had a nervous laughter, and I'm not talking about a giggle, I'm talking about a outburst of laughter as he went through his testimony. So he was talking about the most complex of RCRA hexavalent chrome science in the environment, and would routinely bust out in laughter. And trying to explain to the court, watching DOJ try to explain to the judge that occasionally this world-renowned expert is just going to laugh out loud in this very stodgy judge's courtroom was impressive, and how they framed it was amazing. And the testimony at the end, the judge literally said he might have been the best witness that they've ever seen, period. And the agency won on all accounts. But that experience of making sure you understand the good, the bad, and indifferent of your expert, and prefacing it when you need to the court, was really instrumental in that whole relationship with the attorney and the expert.
I think one of my experiences I enjoyed the most was working with the American Thoracic Society on the amicus brief we worked on about the crystalline silica standard. And part of why it was my favorite experience, well, ultimately the standard was upheld, so that's nice when the position gets wins, but also it just was such a perfect give and take, and it's so rare to sort of get that level of where the expert comes in and gives you, this is missing, and they listen to me when I say, oh, if we could have this part, this is missing. And I remember one thing in particular they fought me on. I wanted what they called vignettes. So examples of cases where someone had been affected by having health effects of crystalline silica exposure, and they were like, well, the litigant, the petitioner, this was a U.S. Supreme Court case, doesn't want that, and so we don't want to do that. And I'm like, these stories are so important, y'all. It really, this is a person. Like, now you're not just testifying, this is a person who it happened to, and it just was so impactful when we finally got it down in writing, and they said things in an impactful way. It was just a nice meld, and that's why it was one of my favorite experiences.
Yeah, I'd have to say a highlight story on this topic would be a few years ago. We had an expert working for us on a renewable fuel standard rulemaking, and there were floods in Texas. And this guy was the most dedicated guy I'd ever seen. So his house flooded. There's no electricity in the neighborhood, but he still had internet access through his cell phone, and his laptop had battery power in it left. And we're kind of in the last couple of days of getting it in. And the dude was basically propped up in some bizarre location in Texas, not in his own house because it was flooded, on his laptop via internet through his cell phone, knocking out expert reports at the last minute, which we were very impressed by, and which was, kind of completely unnecessary. We would have been perfectly happy. And I think the EPA, obviously still would have read his report if we had submitted it a week late, given the Texas floods. But he's pretty hardcore. He really wanted to get it in that time. So that's the most entertaining. But then hopefully also speaks to kind of the issues we were talking about earlier, which is, if you've created an environment where an expert feels like part of the team and feels respected and valued and all that kind of stuff, then you can expect that sort of outcome, right? If that's not how you run your shop, then you might get a different reaction in that type of situation, right? So.
Thank you. Those were great. And Scott, this question is for you. What advice do you have to lawyers when they're dealing with experts? How they communicate with you? Really, what are your top tips?
One that we already talked about, there are no such thing as dumb questions. Really get comfortable with what the expert is saying and take it to that next depth of understanding for yourself. Because if, again, you don't understand it, there's no one else in the case that's going to understand it either. That expert has to be able to relate to the full spectrum of understanding of the issue, and they can't be just off on their own world, providing their expertise. Making sure that the expert has enough time and bandwidth to take on the responsibility. We talked about it earlier in this screening, but the expert can't be an expert on 9 cases simultaneously and give you any fair deal when it comes down to that, court-ordered important part. So I would ask all of those questions. I mean, it is great to have the expert on something, but it's even better if you have an expert who's committed to your matter that's going to get you through all of it, than just have the world-renowned person who's so overly busy and overly booked that he or she or they won't be able to get to you when you need it.
Thank you. And I'd like to take the last few minutes to let the three of you end with any thoughts you've had during this webinar, anything we didn't get to. So let's go reverse alphabetical, if that's all right, and start with Shay.
Sure. So I think my concluding thought on all this is just that it's a real joy, right, to be able to get to do, I think, what lawyers do in working with experts, right? Like, you don't even have to know the science, right? You're getting paid, or you get the opportunity in a pro bono case to learn about a new issue, to work with a scientist who's an expert in the field, and to kind of transform their expertise into something that's useful for the client, right? And I think it's such a privilege to be able to be in a profession where you get to be in that position, where you get to utilize these resources to really help people. And I think if that's your approach, and you kind of respect both what the client is trying to achieve and what the expert has to bring to the table, while again bringing to bear your skills, which are in advocacy and understanding the legal system, I think that's the formula for having a generally productive relationship and result for everyone.
Thank you. All right, Lisa, you're in the same order both times.
Yeah, just definitely don't be afraid to use an expert, but don't be afraid to limit what you have the expert talk about. I think that would be my main tip. There are, I think Scott brought this up early on, but there are certain things that I think are just more effective. Again, I'm thinking about most of the cases that we deal with, going before an agency to produce expertise that's eventually going to be to a court. So don't forget that, right? If you're in the administrative process, you're talking to an agency, really, at least the way we think about it, you're talking to a court ultimately. And because as Shay mentioned, the agency's got expertise, but so you could maybe say things that are less simplified before the agency than you could get across before a court. But if the next step is a court, then think about the court as your audience, and always simplify over having something be overly complicated. Also, that case I mentioned was DC Circuit, not the Supreme Court. So I said that wrong. That's my best too.
Thank you. And Scott?
Well, again, this session will reinvigorate me to try to work with my fellow retired professionals to have them invest in such worthy, responsible activities as pro bono technical practitioner / expert advice. And it's still a huge need, and it's one that I think the folks that I've worked with over the years and know can certainly fill additional more of the gap than we're currently doing.
Thank you. And I do see we have a question asking if ELI is doing anything in particular to raise awareness of the clearinghouse case options availabilities in the environmental engineering consulting expert community. And I think that is a wonderful question that the Clearinghouse, as most of you know, launched this year in February. And so this year has really been about getting the word out to communities, to lawyers, but something we're really striving to do is to engage all types of people, including non-legal experts. And that is going to be a major push next year. That's something that I really want to focus on because experts are such a pivotal point in a lot of these matters, and something that we can't really do this without. So thank you for that. And that is something we will be working on. And if you have any desire, if there are any of you want to join as a legal capacity, as a non-legal expert, please let us know. That the Clearinghouse website is in the chat. I will also put our team email in the chat right now, so you can email us. It really comes to me, so you'll be emailing me and our wonderful research associate on the project. And we can't thank you enough for your interest in this topic and your interest in supporting and engaging with the Clearinghouse. I'd also like to give a very big thank you to Scott, Lisa, and Shay for sharing their wonderful knowledge, tips, advice, stories with us this afternoon. It really has been illuminating. And thank you to Madison as well for being the wizard behind the curtain during this webinar. And again, thank you all so much. And we look forward to seeing you in January, that we will be back in the new year, either in January and February, with the 5th installment of this series.
Thank you so much, Christine. I just want to end with a couple quick notes. Lastly, and the biggest thing is, thank you so much to our wonderful speakers. Thank you to Christine for moderating, and to Scott, Shay, and Lisa for speaking. This has been such a great webinar with practical information for our attendees. We so appreciate you being here with us. A final note for our attendees, please fill out the Google form if you've not already done so and you're seeking CLE. The code is ELICLDEC22. That's ELICLDEC22 with no spaces. We'll track your attendance via Zoom's attendance report and send out our uniform certificate of attendances to everyone who attended the full program and accurately submitted the code. We'll also be sending out a survey, so be on the lookout for that. And with that, I think that's everything I had for now. Thank you for being here today, and please be on the lookout for future ELI events. We will be continuing the series, as Christine said, in 2023. You can find out about the future events in this series and all of our other ELI events at eli.org. Have a great day, and thank you, everyone.
Bye-bye.